Cloud.
It
All
says
right.
recording.
There you
All
go.
right, here we go. Thank you, everybody. I am Angela Hubbard, Executive Director for NARI Metro DC, and we are excited to be here today. First, I'd like to thank our flagship sponsors, T.W. Perry and Ferguson. They do a lot to support us behind the scenes, and we really appreciate that. We're here today with Thomas Croessmann. And Thomas, will you do me a favor? Will you tell us a little bit about yourself and your company, and then introduce the rest of your team today?
Sure. So as many of you might know from just meeting you at the various events, my name is Thomas Croessmann. I'm a partner with the law firm of Croessmann in Westburg. We're based out of Tyson's Corner, Virginia, and we are a construction law firm representing mainly general and subcontractors in both residential, commercial, and federal government contracts. With me and my co-presenter today is Kevin Weldon, who our firm associates with to handle basically all of our bankruptcy matters. And so we'll hear from him a little bit later, but I want to extend my thank you for you listening. This is not necessarily the most popular topic. However, it certainly is an important one, and one that we see people run into and then find out that they've made numerous mistakes along the way, and those mistakes have cost them dearly. So the purpose of this presentation is actually not to be a very long one. It's more to give you some 10,000-foot view of various options that you and your company may use when you're in a hard time. If your company is not in a hard time, you still may find some of this stuff valuable, especially some of the issues that we're going to talk about up front in the first half of the presentation. I'm going to be talking the first half, and then I'm going to be turning it over to Kevin, who will be talking specifically about Chapter 11 bankruptcy, which there's a whole bunch of chapters, but the thing that's unique about Chapter 11, and Kevin will explain it more, is that it allows the owner to go through bankruptcy and maintain control out the other end. Again, Kevin will explain more of that. So what I'm going to be talking about in the first half is pre-bankruptcy issues. So what does that mean? Okay, you're in a situation where your company is struggling financially. Maybe that's due to COVID-19, maybe that's due to the economy in general, maybe it's something totally unrelated to those. Regardless of why your company is struggling, what are some steps that you may need to take and may want to look at to see if they'll work for you? So the first thing to remember is that whether you're in a recession or not, cash and cash flow are king. So the ability to maintain that cash and that cash flow is going to be the thing that's going to help you get through that tough time. So let's talk about incoming money sources before we talk about outgoing money sources. So for most contractors, there's only really one source of income, and that's from the homeowners, from you working on their construction projects. So how do you help make that collection system better? Well, the first thing to do is to look at your contract and really understand it, and understand what your payment terms are. And then what we say is tighten up your collection system. So what does that mean? That means hold your homeowner to what they've signed in that contract. So for example, if you have a contract that says that the homeowner must pay X amount of dollars 30 days after that you've sent an invoice, well, hold them to that. Don't let them go 60 days or 90 days before paying. Because if they go 60 or 90 days, well, let's say 90 days, if they go 90 days and then they cut you a check, 9 times out of 10, you're not charging any interest or late fees. It's just what I see. I mean, maybe your company's different, but most of the companies I see never charge any interest or late fees on that. So what have you done in that situation? Well, unbeknownst to you, you've just financed the job. In essence, you've given them a 2-month short-term loan at 0% interest. Why? I mean, that's the real question. You're not a bank. You're a contractor. You're there to build the project and get paid for it, not there to help them financially. So really tighten it up And we'll also talk about why those time periods are important when it comes to enforcement in mechanics liens. But you see so many times the homeowner comes and says, oh, I've just gotten this. I know I have to pay you in 30 days, but something has come up. I'm on vacation. I just give me a couple more weeks and I'll pay you. And 9 times out of 10, the contractor's okay with that. And they'll kind of be like, yes, you'll get it to me in a week. You'll get it to me in a week. Well, weeks turn into months, which turn into many months, which turns into potentially disastrous situations for you. The other thing is that you want to figure out at what point are you going to turn over that delinquent that delinquent situation. Are you going to stop working? You really want to check your contract to see if there's anything in there about whether you can stop working on the project. I would certainly recommend you get with some lawyers and counsel to maybe go through the contract with you and talk about your options. But one option may be to simply stop working. Because if you think about it, if you are past the day that they're supposed to pay you, so let's say 60 or 90 days, and you continue to do the work, now what are you doing? Well, you're financing the job and you're also making improvements to their property. I mean, you're kind of getting hit twice. So you really want to make sure you understand, okay, can I stop working? What does my contract say in regards to if I do stop working, and how can I resume working if they do come current? Hopefully those are explained in your contract. And again, seek legal counsel on that before you maybe get in that situation and stop working. But if you've exhausted those two issues, then the question becomes, okay, what do I do? Do I turn it over to a collection agency? Do I turn it over to a lawyer? Do I write threatening letters as the owner of the construction company? There's a wide variety of options, but this is just my 2 cents. Not really as a lawyer, just kind of as somebody that's seen this a lot. Collection companies can be good, but they serve a very limited purpose. They are not attorneys. So why is that important? Well, that means they cannot sue you or sue for you. And they also don't file mechanics liens for you because, again, not attorneys. What we see them typically do is send demand letters, usually using automated voice recordings. They'll make calls, and that's pretty much it. Again, can be effective. They tend to be a pretty low price point, but you may actually, if you go that route, lose out on some other options that are available to you. So if you go the lawyer route, for example, what options can be available to you? Well, you can sue, or you can file a mechanics lien. And let me be clear, you as the contractor can do that, and we'll talk about why that may or may not be a good idea a little bit later. But those are the two other options that you can do. So if you hire an attorney, you can file a lawsuit and try to get a judgment and then collect on that judgment. The other thing is you can file a mechanics lien. Mechanics liens are a huge topic, and frankly, I could talk about them for hours, which is obviously beyond the scope of this presentation. But they are important to know a couple of key things. You do want to file a mechanics lien if you meet certain criteria and if the situation calls for it, because mechanics liens are very powerful tools, especially if your homeowner is having financial difficulties and are looking at filing for bankruptcy themselves. If you have a mechanics lien, that's a secured lien, and you have a higher chance of getting paid through the bankruptcy than if you were to without filing the mechanics lien. Again, that's really, I'm kind of stepping on the toes of Kevin. I don't think he's talking about that in this presentation right now, but keep that in mind. So what are some really important things to keep in mind at the 10,000 foot level for mechanics liens? One, and this is generally speaking kind of across multiple jurisdictions in Maryland, DC, and Virginia, where I practice, you have 90 days from the last time you were on site working to file that mechanics lien. Some a little bit more, some a little less, but general rule, 90 days. And you may think to yourself, well, hey, Thomas, 90 days is a long time. But if you think about it, it's really not, because one thing to remember is that it's 90 days. It's not 90 working days, which means weekends count. Holidays count. Now, the only exception is if the last day falls on a weekend or falls on a holiday, it goes to the next working day. But for the most part, when you're counting those 90 days, all those things are included. The other thing is that if you have a situation where your contract calls for the homeowner to pay 30 days after the invoice has been submitted, well, think about it. You just gave up a third of the time you had to file, which means you don't even know if that homeowner is delinquent on that payment until day 31. And so now you can see where a situation where you're finished with the project, you send them that final invoice. They have 30 days to pay you, and day 31, you find out they're in default. But maybe you don't find out at day 31. Maybe you find out at day 60. That clock keeps ticking, and you may run out of time. And once you pass that 90 days, that's it. You lost it for 9 times out of 10. The other thing to keep in mind is that there is a very special rule that affects only 1 and 2 person dwellings. So what does that really mean? It means single family homes and duplexes. But there is a special notice rule where you may, if all the situation is in place, you may actually lose your right to file before you even start working on the project. So again, at a 10,000 foot level, without getting too complicated, if you ever look at a building permit, there's a spot where it says mechanics lien agent. Now, 9 times out of 10, nobody's listed there. But on the off chance that somebody is listed there, and it's a single family house or a duplex, you actually have to give what's called pre-construction notice, which means that you have to give notice, I believe it's within 30 days of you starting on that project, to the mechanics lien agent that you're working on the project and you have basically mechanic lien rights. And if you don't, you may have waived your ability to file a mechanics lien. Now, who is a mechanics lien agent? It's only 3 types of people are allowed to be it. They're attorneys, they're financial institutions, so banks, and then title insurance companies. So where we see it the most is with the title insurance companies, and I guess with banks. But your mileage may vary. Again, most people don't see it, and so therefore it's not an issue. But it is something that if you're getting to that point, or if you come across that on a building permit, you might want to go, oh, maybe that's a red flag. So the other thing to keep in mind is if you decide to hire an attorney, a lot of attorneys are bound by what's called the Fair Debt Collection Practices Act, because any time that we try to collect money from a homeowner, we qualify under that act. And why is that important? The reason it's important for you all to know about it is because we as attorneys have to give the homeowner 30 days of notice before we can file a lawsuit and before we can file a mechanics lien. Otherwise, it's a violation of that. And again, that's beyond the scope of this conversation. But why does that matter? So if you come to me and you say, hey, Thomas, it's been 30 days, it's day 31, I want you to send a letter. Great, no problem. Send a letter, 30 days passes, we're at day 60, I have plenty of time to file a mechanics lien. You come to me at day 61, may not have enough time. We'll have to really closely analyze that to see if there's enough time to file a mechanics lien. So those are some things to keep in mind. When we say tighten up your collection, it really means look and see, is your current collection system working? Do you even have one? I mean, look, I run into a lot of companies that don't even have one, and there's nothing wrong with that to a degree. So that's where we start, because that's all about incoming money, right? So the next step is to, if you're in a financial hardship and in a tough spot and you're not receiving that money, is, well, let's talk about outflow of money, okay? Subcontractors and vendors. Well, for subcontractors, the first place you want to start is looking at your subcontract, because there may or may not be a provision in there called a paid if paid clause. And what is a paid if paid clause? Well, a paid if paid clause says that I, the general contractor, do not have to pay you, the subcontractor, if I don't get paid from the owner for the portion of work that you did. Now, a lot of people come to me, and after I explain that, they go, Thomas, that seems really unfair. But if you think about it, all it's doing is shifting the risk down to the sub, because you don't want to be stuck as the general in a position where you didn't receive the money from the owner and you have to pay it out, but you still have to pay out money to the sub. A very easy example is you were supposed to receive $100 from the owner, but you owe the sub 90 of that $100. You didn't receive the 100 and you do pay out the 90. Well, now you're actually out $190, and you as the general are really bearing all of the brunt of this terrible situation. So the first, and those are very enforceable clauses, by the way, and they're legal in Virginia and in most jurisdictions. Your mileage does vary, so check with your local counsel on that. But for the most part, they are enforceable, and we write them in, I would say, almost every single one of the contracts that we do for subcontracts. But let's say you don't want to go that far, or you don't have that in your subcontract, or maybe you don't even have a subcontract at all. What's the next step? Well, go to your subs and simply ask them, hey, I know I'm supposed to pay you 30 days after you do the work, but I haven't gotten paid. Can we extend it out to 60 or 90 days, or try to do some kind of informal or writing is always better, but try to do something where you come to an agreement and have some communication with them and see if that will alleviate some of the hardship for you. So the other thing you want to think about is vendors, right? You don't tend to see too many vendors have paid if paid clauses because they just don't really work that way. So if you really are in a terrible situation, you're thinking, bankruptcy might be right. I have a little pot of money, and it's not enough to pay everybody, but it is a pot of money. It's available cash. One potential option, instead of going through bankruptcy, is to do what's called a workout. And what a workout is essentially you go to your subs and your vendors and say, look, I didn't get paid on a project or a series of projects for this reason or for that reason. It doesn't really matter. But I do have this pot of money, and I'd like to work a deal with you to get that obligation that I have released. And if I don't, I'm frankly going to file bankruptcy, and you may or may not get paid anyway. And so therefore, I'm going to offer you cents on the dollar. And a lot of people think, well, why would I ever accept that? Because you know what? Some money is better than no money. And they can actually work out very well, especially depending on where your sub and your vendors are with their own mechanics lien rights. For example, if your subs have passed the 90 days and your vendors have passed 90 days, they may not have a mechanics lien right. And the only option available to them would be to file suit against you as the general. And a lot of people don't want to file suit. So doing a workout and taking cents on the dollar just to close that account out, get that off their books and move on, may be a good option. The important thing to remember, though, is if you are going to be doing a workout, is don't do it alone. Talk to your accountant, talk to your lawyer, because you want to make sure you do it in a proper way. You want to talk to your accountant about what is the best way to structure this. You want to talk to your lawyer about the best way to structure this. The other thing is you want to make sure there's documentation related to it. You don't want to be in a situation where you orally agree with a sub, for example, that they're going to take 10 cents on the dollar. You cut them a check, and then they come back to you and say, well, that was just a partial payment. That gave you a little bit more time. Maybe I extended it for 10 or 15 days, but I didn't discharge the entire debt. Well, that's where a lawyer will help you and make sure that you have proper documentation, whether it's a release or something else in place, when that money is actually given to them as part of a workout, they are signing away that you have that obligation anymore. So those are some pre-bankruptcy things to talk about. I would say there's probably two or three more things I want to talk about before I turn it over to Kevin, but those are the main points I wanted to really give to you. The other thing from a business perspective to look for is, are there maybe small, low profit jobs that I can just do just to get by, to see if this rough patch ends. Those may be very good for you. Just, even though they're low profit, keeps people on the payroll, keeps the company running, and some profit's better than no profit. Obviously, looking at something like the PPP or a small business loan or those types of things are good. To some degree, this whole conversation is with the assumption that you've done that and have exhausted those potential resources. And the final thing is to be aware of big long-term projects, especially ones that you're not really used to, because we do see this a lot. You have a huge project and you go, man, if I can just get this project done, I will be set. There's tons of profit built in. We're going to make a ton of money and it's going to solve all my problems. I hear that time and time again, and something occurs and you're never going to finish that project and you're never going to get that actual profit. And I know that I said that was the final thing, but I do have one thing that I get as a question. And Kevin, I know, sorry, I'm taking up more of your time, but I get this question a lot. Thomas, can I just shut down my company and start a new one? And the answer is probably not, for two reasons. One, there is this thing called successor entity liability. The courts, they're not stupid people. They've seen these things happen before. And essentially what they say is, look, if you shut down your company and you start a similar company, just maybe under a different name, and the ownership is the same, you're doing the same stuff, you may even be working on the same projects that you brought over. They're going to essentially impute that debt over to that new company, and you're not going to have it discharged, or you're not going to have it go away. The other thing is it may actually be considered a fraudulent transfer. If you shut down this company A over here and you try to start company B, and you go and you take the projects, but you try to leave the debt, they're going to consider that a fraudulent transfer, depending on the situation and the particular facts. And again, your debt won't actually go away. So that was all pre-bankruptcy stuff. And these are all just tools. One is not necessarily the best avenue. You want to talk about all of this in conjunction with this bankruptcy option that Kevin's about to talk about. Don't think of them as bad. We are fortunate to live in a country where you can go through bankruptcy, and that's totally fine. It's an amazing thing. So when you go and you talk to your accountant and your lawyer, these are all things to think about holistically. So Kevin, now I'm going to hand it over to you, and you can talk about bankruptcy and that tool and the new tool that's become available.
Thank you, Thomas. As Thomas said, bankruptcy, I think a lot of people have it's kind of a scary sounding term. I think a lot of people are familiar with Chapter 7 liquidation bankruptcy, and maybe know someone who's gone through that as a consumer or an individual. But Chapter 11 is a nice option for some people, and it's Thomas said a while ago about tools. It's a tool that's out there, and the beauty of it is it allows you to go through the bankruptcy process, get rid of debt, have some time to reorganize some debt, and come out the other end still with a business, and hopefully a successful business that you can continue on for years to come. As Thomas said, there is a new tool, and if anyone's familiar with Chapter 11, there are some things in Chapter 11 that can be somewhat time consuming or a little bit burdensome to debtors, like committee meetings and the debtors, the creditors, meetings. But this new Subchapter 5 was created in 2019 with the Small Business Reorganization Act, and basically it's helped to streamline the Chapter 11 process for small businesses. And by streamlining, it's done away with a lot of those things. There are generally no creditors committees. You generally have a right, exclusive right as the business owner to follow your plan. And it's done away with some of the things like the absolute priority rule, which without getting too in depth, is if you had any equity in your business, secured creditors could squeeze that equity out of the business and leaving you, without that equity coming out the other end. But it's done away with that in the subchapter 5, and it also allows, if you've used equity in your home to put into your business, it allows some reorganization of that as well, which are things that weren't available in the previously in Chapter 11, which has made this process, especially with what's going on now with the COVID-19, an option that may be attractive to small businesses who are in that situation where they need some relief and they are thinking about the process, but had heard about Chapter 11 and some of the things that have gone on or gone on through a Chapter 11 previously. Those things are now not a part of the subchapter 5. And another thing that has taken effect in the CARES Act is previously a small business who would have been eligible for the subchapter 5 with someone that had less than $2,725,000 in total debt. That's been increased to $7.5 million of total debt. So any debt up to $7.5 million, you would still qualify now since the CARES Act as a small business and be eligible for the subchapter 5, Chapter 11. The only caveat to that is that there is a sunset provision. This is only good for a year. Beginning, I believe it's next March, the debt's going to reduce back down to the $2.7 million number. So there is a time limit of, this year, unless the law gets changed again, and it would reduce the debt back to 2.75. But right now, anyone who has debt up to $7.5 million is considered a small business under the Reorganization Act of 2019. So that has increased that substantially and during this period, and given more people this option than would have had that a year ago. But I think the overall aspect of filing bankruptcy is, what relief do I get? What does it do to help me, and how do I come out the other end, being able to run my business, and why is this something I can consider? As Thomas has gone over, there are some various options that can be done prior to bankruptcy, but sometimes you find yourself in a situation where the debt is just unmanageable, and you're looking at a situation. But Chapter 11 is an effective tool, because unlike a Chapter 7 where you shut down your business and just sell your assets, Chapter 11 allows you to continue to operate while you're paying off those debts. And it allows you to pay back, partial payment on certain unsecured debts. And at the end of the bankruptcy, those debts are discharged, which means they go away, and you can get out from under that debt. The other benefit is the automatic stay. The automatic stay is the court order which prohibits, or it's an injunction against creditors calling, harassing, taking any sort of collection activity, and that begins upon the filing of a bankruptcy. And that's very powerful tool, and it comes with the full force of the bankruptcy court, and it stops creditors from coming after any funds you may have, or taking you to court, or otherwise harassing you as the business owner. And that lasts throughout the bankruptcy process. And you can restructure your debts through the plan. And with the new subchapter 5, there's that's made that a lot easier to do, which gives you time to pay back those debts. And by giving you time, by giving you the automatic stay, and getting the creditors off your back, so to speak. It kind of gives you some room to breathe, operate your business in a more efficient manner, and manage those debts and come out the other end of that without those, by discharging those debts, you come out without having that burden, and you can operate your business effectively going forward, and still have that ownership. And, with that, I'll turn it back to you, Thomas.
Yeah, thank you, Kevin. One thing I want to make sure that everybody's very clear about, even though we separated this presentation into kind of pre-bankruptcy and then bankruptcy, they are not mutually exclusive. In fact, if you have a pot of money, it may be best just to go through the Chapter 11 route and not do a workout. From my understanding, and Kevin, correct me if I'm wrong, but Chapter 11s work very efficiently and effectively when you actually do have a pot of money. So if you try to do a workout and you have given all that away and it's didn't solve the actual problem and you still have a lot of creditors out there, and then you go try to file Chapter 11, well, that's part of a reorganization. You got to have something. And if you don't have something, you may not be very successful. So when you do have that pot of money, or if you have that pot of money, I should say, you don't just want to haphazardly spend it or try to do one of these things without really consulting an attorney and an accountant, because you really have to think about workouts and bankruptcy in the same time. So that is our presentation. Again, it was designed to be kind of short and 10,000 foot view. So if you do have questions, feel free to contact us, and Angela has our contact information, and we will be certainly happy to help you. Thank you, everybody, for coming on out.
Thank you, guys. Thank you, Thomas. Thank you, Kevin. And just so we're clear, I will be sending out a post-webinar email with your information, and that way people can review this as they need to and then reach out to you guys if they should need help. I know this is a sobering topic, but it's very relevant for today, and we want to make sure that if this is a path that our members are facing or prospective members are facing, we have given them the best legal advice that they can get. So thank you both for joining us and helping our members.
Absolutely. And the one thing I will say is we do tend to see people come to us a little too late to really do things effectively other than maybe just file bankruptcy. So if you, and that's, again, as Kevin talked about, not necessarily a bad tool, but the earlier you can see this coming is the time to get help. Don't wait until, hey, I have no money and I have millions of dollars in debt and everything is crashing down around me. With our current clients, we can see it a little bit better and get a little bit more insight, and we do see it coming farther. But when people come to us and we don't have a prior relationship and they just come and say, this is what I've done, it may or may not have been the right thing. And so if you are struggling, seek advice as soon as you can.
Excellent advice. That makes perfect sense. I think we all just try to keep fighting and keep staying afloat and then realize that it's too late. So I appreciate that, Thomas. All right. Well, you guys enjoy the rest of your evening, and thanks again for being with us. We appreciate it.
Absolutely. Thank you.